Welcome to Status Secure, the weekly cyber threat briefing for executives who refuse to operate in the blind. Hosted by the Watcher 6 Collective, uniting former Army Special Forces and Naval Special Warfare Communications operators, alongside an industry-leading CISO nominated for Cybersecurity Woman of the World. We cut through the noise and give you the operational intelligence you need for mission success in a hostile digital environment. The enemy is listening. Is your status secure? Welcome to Status Secure. Today's transmission is for the investor side of the equation. So we talk a lot about how companies can implement cybersecurity measures, security measures for various reasons. But today we want to talk about something in regards to an event that took place in March of 2026, where a federal judge in California issued a ruling that rewired, in a way, cybersecurity diligence for the investment community. So what happened is the judge allowed a class action claims against Bain Capital, who was the buyer of PowerSchool. And PowerSchool, they had a data breach before the acquisition happened, where 60 million students, 10 million teachers, there were stolen vendor credentials, ransom demand, 2 months. This all came to light after the close. So the federal court that decided the acquirer in this case had legal liability and was responsible for the seller's pre-acquisition cybersecurity failures. And so this is what we wanted to talk about today is, if you're deploying capital in 2026 and your diligence framework hasn't been updated since March, you're personally exposed to maybe this happening. So now we have a new precedent. And, we were discussing this topic, CISO, and we were originally discussing this from the side of PowerSchool, or from the side of the company itself. Let's call it a startup. And when we were talking, you thought that, hey, we should probably focus on the other side of the equation. So why don't you dig further into that for us?
Sure. So you mentioned PowerSchool. So let's talk about that, right? So PowerSchool is this startup company that created an application where parents and students and teachers and educators could view grades, homework, attendance, right? All of that in one place. So, and then they took off because everybody started using them because one school started, then it went to 2 schools, 3 schools, you see, right? Exponentially, right? And so they became a really big player in this space. And so, of course, then investors got interested, right? Investors got interested and wanted to purchase, right, and invest in the company. So when you're doing sort of like or you're acquiring them, right? Like, so you're investing or you're acquiring them into, like, especially in funds that are buying companies and making it part of their portfolio. There's a process that happens. You verify their SOC 2. There's not what they call qualified or unqualified, right? So there wasn't any findings that were too egregious in their SOC 2 or any that they didn't fix, right? You're looking at, you're confirming that, hey, they disclosed all of their breaches, right? And then you take a look at those things, like a checklist. And if everything looks good, then you're like, okay, we'll put our money here. And what happened was, like, the warranties, insurance policies, what people assumed is that and they assumed that, PowerSchool, there's a time, there's a date when they sold it, right, to this fund or to this investor or this, acquiring company or whoever. So anything that happens before that date is not the new owner's fault. Everything before that is the PowerSchool, the previous owner, right? That's what everybody, assumes it is, right? And that probably used to be how courts used to rule. But what happened was with the PowerSchool, because they had some serious security events happen after the purchase. And so it comes to, like, all the damages, because now people are suing because their data and their children's data was breached and exposed. So now there's a class action lawsuit, okay? And that's a lot of money. And so now it's like, who's liable? when you go to court, what they're looking at is who was negligent, who was aiding and abetting, right? And that kind of determines, like, does the previous owner pay 10% or 90%? Does the new owners pay, right? So what the court said was that the, what they said was that the acquiring company actually owns the liability. They should have done their due diligence. They should have really, really take a look. And then once they took ownership, it's now their responsibility to make sure the security is there. What happened before is no longer the current state. So the seller isn't really as accountable as the acquirer. So let's say you're the fund that acquired PowerSchool. Now you have to write a letter out to all of your, it's usually a limited partnership that owns. And so now you've got to write out this letter. Okay. And you have to explain like what happened and basically the fiduciary failure that happened. That right now your fund owns a company that's in the middle of a class action lawsuit.
Yeah. And, something about the startup community, I would say there's a common conversation around security. Whether it's right or wrong, I don't know if that matters, but a lot of the mindset in that world is sort of don't worry about it. It's kind of like you don't have much of a budget. You're trying to build a product. You're trying to get customers. You're trying to become something worth the investor's time, right, and attention. And so build it. Get customers, start making money, right? And when, you hear some of these conversations of like, hey, should I invest in a certain amount of money into my security? It's like, there doesn't seem to be kind of a urgency behind that. You get a lot of like, put the money into sales and marketing and we'll figure out cyber on the back end. And so I would imagine as on the flip side, if you're a venture fund of some sort, and this is like the basis of what you do, is to find great golden, opportunities that look like they're going to bring in good ROI for your LPs and for you and put them into your portfolio. And so this situation is a good one to discuss. It's a good precedent because I think now we can look at it from that side of the house of going, it's another thing to look at, right? It's another piece of the puzzle to, when we're doing our due diligence, to look at and go, hey, did you guys do this? Did you, if you are in that world and especially where you need it, did you do it? And let's make sure it happens. I know something that, some of these companies will do is they'll come in with their legal teams, right? The venture firms can afford to have, a big four legal team where maybe the people who started the company couldn't. And so there will be this due diligence around legal contracts and things. And I feel like this sort of falls into the same place of, now we're doing due diligence around our security, which is important. If you can get into trouble because of not having IP type contracts with maybe the people who help build your code, you can also get into trouble with, like what happened with PowerSchool, by not having proper security when you built it to a certain size. And so what would you say, does a PE, private equity partner or a venture capital, partner, or just people that work at the firm that are working on these deals, what can they do differently in their diligence to make sure this doesn't happen to them?
I mean, sorry, the PowerSchool thing is public information, so you can look that up. But for the investment people, what you want to do is, there is always a lot of rigor around financial risk. That's been around for a long time. When they're investing, they look at ledgers, they, scrutinize, they hire, forensic accountants, right? Like they go all out to look at the financial risk before they purchase a company. When they look at security, most of the time they're like, oh, okay, did they get a SOC 2? Yes, they did. We're done. You can see the difference, right? You can see the difference right there. So a real risk assessment, a real security risk assessment, quantifying the cost of undiscovered breaches, the cost of remediating gaps, all of those things need to be performed to the same kind of rigor that you would on the financial risk side, you need to do on the cyber risk side. A good example is Yahoo. So Verizon wanted to purchase Yahoo. So Verizon did their due diligence. They really dug into Yahoo security, and they found that Yahoo did not disclose some breaches. And, in order to find that, they really dug deep. So what happened was, you know, they originally offered $4.8 billion on Yahoo. Once they found that Yahoo had not disclosed breaches that they were not aware of, they were able to negotiate and reduce by $350 million the offering price. So when you're the private equity or the venture capitalist, when you're these things you need to do, because in the end, it actually helps you with your negotiation, because you don't want to and then go in and realize, oh no, now you have to spend millions of dollars to fix their security, right? Why not say, hey, we're going to have to fix your security. This is how much it's going to cost us. So we're going to reduce that from our offering price.
Yeah, you brought up a great point. What is people's number one complaint about selling their companies? To the acquirer, it's the negotiation and how frustrating that process can be over a long period of time. And one of those things, what you brought up, is what you'll see is, we're going to negotiate this, and sometimes it's just to see what they can get, right? Just to see how much they can knock down the purchase price, because why wouldn't they? It's business, If I can bring the purchase price down and make a bigger ROI, great. And so that's maybe a reason why it can last so long. However, on this aspect, this is great for them, because you're not just saying, here's a tactic to help you negotiate from the investment side, but you're actually killing two birds with one stone by saying, here's a way you can knock down the acquisition price, but also cover your ass, right? Like a little CYA, and make sure that you don't get screwed because of a cybersecurity breach in the future. So it's not just a money thing, which makes me feel better. It's going, no, this is real, and you guys needed to have security. You should have had it. We're still interested in acquiring you. However, we got to knock the price down like what Verizon did for a valuable or viable reason. And this is important because we don't want to have to deal with your breach, maybe, right? And we want to make sure that we have implemented good cybersecurity, like good actual, maybe not just like a certification on the wall that says I've been certified, but maybe like actual security. So when things happen, because they can happen all the time, they can happen tomorrow or 6 months from now, they're protected. And because a piece of paper isn't necessarily going to protect you. So this kind of segues us is when now you got me thinking that I come in, I'm doing my due diligence as this acquiring company. I brought on, one of the big four consultants to dig through their financials, or someone to dig through legal, whatever. So now how does that look from the cyber side, right? So now, okay, this sounds good. This is great. Add it into my team here as we go in and do our deals. So now when I want to pull out my cyber team and put them into the diligence process, how does that look?
Well, usually, you want to look for 5 things. One is secrets in repositories, which is basically, passwords everywhere, credentials not secured properly, right? Because that's an easy way for threat actors to get into your systems. When you were in the startup phase, you hired a developer who came in for, to build something, and he's the one who coded it. He's the one who had the credentials, and now you've never changed those credentials, and it's somewhere out on like GitHub, So, those things, you want to look for those things. Undocumented data flows. What this means is that, that they need to know where all their data, is going, the flow of their data, especially highly sensitive data like customer PII. Like if they can't show you where all the data is going and where it's sitting, and that's kind of a red flag, right? Because now you have exposure that you're not aware of. Production access sprawl. This is I see this all the time in startups. They give everybody admin rights because they need to move fast. So over permissions is everywhere, and they haven't fixed it. Missing audit trails. So if you ask them to show, hey, what customers access what data, and they can't, you have 2 problems. You have one, which is they don't know how to configure security. That's a telltale sign. And 2, you really don't know who's accessing what. And so again, it leaves you blind. You're basically sitting at the casino just hoping to win, right? And of course, like the vendor, right? Because in the beginning, they try a lot of different vendors, they try a lot of different products, and they don't keep track of them. And a lot of times because they're startups, they want to save money. So they'll try new products or SaaS that there isn't a real contract. It's just terms and conditions. And so you don't really know like what rights you have with your own data. So those are the things that you should look at to see if, and I'm not saying that you shouldn't purchase them. I'm just saying you need to be aware so you understand the risk of purchasing them and the cost, the potential costs.
Got it. And now just so that we know, if someone listening doesn't know, or just out of curiosity, let's say now, right, starting today, moving forward, we have a company we've closed the deal, right? The acquisition's closed, and then 6 months later we come across a pre-close breach. So what happens? Like, what's the actual cost at the fund level, or maybe for the person who championed the deal? What happens here?
Okay. Well, let's talk about what happened with PowerSchool, because again, they're public. What happened there is public information, so you can just go look at it. So at the fund level, the class action names PowerSchool and the fund. So now you got to hire lawyers to defend, right? To go to court. You're talking $2 to $10 million in legal fees, right? For before settlement. The reputational damage to the fund, like now, people are like, oh, wow, should I really invest with them, right? So, it's harder to really do your next fundraise, right? Because it's going to be fresh. People are going to be Googling you, right? They're going to know what happened. At the GP level, the general partnership level, right? What happens is when the breach becomes public, the GP has to write a letter to the limited partners. And this letter is read by every GP and LP in the portfolio. So again, reputation. And now the PowerSchool situation is going to be attached to your fund from now until, forever, right? And it's going to really cause people to pause. So on the personal liability for the partner, what happens there is that each partner, like their names are attached to it because they have to write letters. And now the letters, they have to sign the letters, right? So the names are attached to it. And then the partner who signed the investment committee memo recommending the deal is on that named defendant list in the class action. So they can be personally liable for that. If I was an investor now, so now I could turn around and sue for damages from that, that partner if I was an investor in that fund. So that's, there's a lot of liability there. There's a lot of financial risk there. As long as you can prove that you did your due diligence. But if all you did was look at a SOC 2, it's going to be pretty easy to prove that you did not, you did not do everything you can, your fiduciary duty to your investors.
Got it. And so obviously we can't slow down the pace of deployment. We can't slow down investment funds, the opportunities that present themselves to us, all of those things, right? We're still going to do business. So in thinking about our marching orders this week for private equity firms, venture capital firms, family offices, whoever the investors are, the acquisition, the acquirer, what are 3 things that they can execute starting Monday without breaking their deal pipeline, but 3 things they can add to better protect themselves in terms of what we've been discussing?
Yeah. So the first is, take a look at your process now. Like, what is your diligence framework for reviewing potential, acquisitions and investments? Make sure that the security diligence portion is more than just verify SOC 2. We made some recommendations earlier. Make sure those are in there. Second, audit the existing portfolio. So just because you've already purchased or invested doesn't mean that you don't have the right to now go back and review, do a cybersecurity assessment, to make sure that, you can say, hey, and you can tell them too, because now you're an investment partner, right? You can say to them, hey, we did our own security assessment and we find that you're deficient in these areas. We want you to remediate these, right? You can give that to the board for them to make decisions. 3 is make sure that you build cyber into your LP reporting, right? Make sure you're informing, like, what are you doing? What's the cyber of, your investments look like? That way everybody's communicated. This is where when you go to court, these things will help mitigate the amount, the dollar amount that a judge will, kind of say you're obligated to pay because of what you do or didn't do.
Got it. Well, hey, that's it for today. Cybersecurity diligence. It's not a checklist anymore, right? It's an added layer to your fiduciary duty. So mission success is about knowing what you're actually buying, not what the seller's deck is saying, but knowing where the data lives, knowing who has access to it, knowing what is in the code base. The trust but verify concept. So let's go ahead and execute to the standard, and we'll see you next week.
Mission success isn't about luck. It's about preparation. You've heard the intel. Now, go put it to use. If you need to verify your security posture, I've established a secure line at watcher6.com/secure. Go there to get the briefing the enemy doesn't want you to have. We'll see you next week. Until then, keep your head on a swivel.